A former Hooters girl is suing the restaurant chain after she claims she was forced to leave her job because she had brain surgery. We're joined once again by WGY legal analyst Chaz Farcher of Martin Harding and Mazzotti. Good morning once again, Chaz.
Good morning, Kelly.
So this is an interesting case. This waitress said she had to undergo surgery to have a mass removed from her brain. And when she came back to work, she still had the wound on the back of her head. Her boss told her she had to wear a wig, but it irritated it. And so she was forced to leave work, and she's saying that violated her rights.
Yeah. The issue is in my mind, is that Missouri, like New York, is an employment at will state. And what that means for most people is that your employer can fire you for any reason or no reason at all, so long as it's not, so long as your termination is not for one of the protected reasons or basis, of which are, discriminatory reasons means you can't be fired because you're too old or too young, or because of your race or your gender, or solely on the basis of a disability. So if you're terminated for one of those reasons, you may have something. Otherwise, generally in New York, just like Missouri, you can kind of be let go for any reason or no reason at all.
Well, she's claiming that she had this brain surgery and therefore it was a disability.
That's right, and that's what's interesting about the case. Normally where we see a situation like this, or commonly where you see a female who's terminated, a lot of the times the discrimination suits are based upon gender. My boss let me go because I was too attractive for a job or too unattractive for a job. And, that's not the theory that she's put forth here, or attorneys put forth here. What they've gone with is the scar on her head constitutes the disability, and that the restaurant let her go on the basis of that disability.
They also, she's also claiming that they forced her to quit voluntarily so she couldn't claim unemployment benefits.
Yeah, and there are a lot of issues with the case I see going forward. First of all the employer is required to do under the Americans with Disability Act is keep an employee who can complete his or her job with or without reasonable accommodations. First of all, the problem with the case is that she wasn't fired. She quit her job. The argument would be that she was essentially or de facto fired because they reduced her hours, but I still think it's a hurdle for her attorney to get over.
So in this particular case, then, she has this head wound, and you have to also look at the sanitation issue, the sanitary issue, because you've got essentially an open wound on the back of your head, and you have to worry about people eating in the restaurant. I mean, I might have some concerns over a waitress with, an open wound serving food.
Well, sure, and I think there's a lot to it as well. Let's be honest, a place like Hooters has a certain type of atmosphere that appeal to a certain type of clientele. So the other issue with the case is maybe the argument for Hooters is that she wasn't terminated. Maybe her hours weren't reduced because of her head wound, but because they have a certain dress code or a certain hair policy there, and she refused to abide by it. And that cuts against the case of discrimination, but rather you start to form the argument of an employee who didn't want to comply with the requirements or the dress code or the atmosphere that restaurant is selling.
WGY legal analyst Chaz Farcher of Martin Harding and Mazzotti, 1-800-LAW-1010. Chaz, thank you so much.
Thanks a lot, Kelly. Have a good day.
You too.